Hello everybody and welcome to today's webinar. We've got a great presentation lined up for you today, but before we get started, there are just a few general admin points to cover. First and foremost, please use the online question tool to post any questions that you have and we will share them with our speaker. Second, if you experience any technical difficulties today, please let us know using that same questions tool and a member of our admin team will be on hand to support you. And finally, just to note, this session is being recorded and we'll be sharing a copy of that recording with you via email in the coming days. So without further ado, I would like to hand over to our speaker, Samir Gokhale, to get us started today.
Hello, everyone. Thank you, Lucy. Thank you to IAM and Lexology for providing this platform for this presentation today. As Lucy said, my name is Samir Gokhale. I am a partner at the Oblon firm, sometimes also known as Oblon, McClellan, Mayer, and Neustadt. Just a little background, I've been a patent attorney for about 16 years, and before that I was a patent examiner at the U.S. Patent Office for 2 years, and I did some other non-patent related jobs before that. I speak a lot on artificial intelligence, especially with respect to patent law, and in particular U.S. patent law. I've done past webinars for IAM and through various audiences all over the world. And yeah, I definitely enjoy being able to talk to you today. If you have any questions, as Lucy said, please post your questions to the questions tab on your screen, and I'll try to address them as soon as possible. If I don't do them during the lecture, I'll try to do them at the end of the lecture. But without further ado, I'll go ahead and get started. So today's presentation is on emerging issues and recent developments on artificial intelligence and IP. One of the things I want to try to talk about today is some different topics that maybe don't get covered in a lot of these presentations on AI and patent law. In particular, some issues maybe separate from 101, maybe separate from the issue of AI as an inventor, but are becoming very relevant given recent events in the news and recent events in the law. Before I get started though, just a little background of where I'm coming from. Our firm, Oblon, we're actually right next to the U.S. Patent Office. We've been trying to handle these issues in artificial intelligence for many years now. We've actually formed a team of people who are prepared to speak to clients or any interested people about artificial intelligence. We've kind of shared our knowledge on this topic for many years now. One of the things we try to do is write as much as we can about the topic, try to look at different issues that affect different industries. We've been paying attention to how this new era of technology has affected things like factory automation, commercial technology, in all sorts of areas, and trying to really keep both our colleagues and our clients up to speed on what's actually happening in this ever-expanding area of technology. In addition to that, I just want to make one more mention. We have a blog that we actually do, the AI Patents blog, and we write about these issues pretty frequently. And if anyone has any topics they'd like to suggest for the blog, I definitely appreciate that. And I'll probably give another link to that before we end this webinar today. And just briefly on the background of artificial intelligence. Sometimes we define it as intelligence demonstrated by machines in contrast to the natural intelligence displayed by humans and other animals. And this next set of bullet points are kind of what I see as the characteristics of many AI innovations, but I'm also going to describe why this is sort of different than what we're seeing today. Sometimes an AI innovation can have a monitoring or sensing function to actually pick up different data points. It can have a learning function to it. It can perform object or pattern recognition. And it can make maybe a decision-making function, perform prediction or make some kind of decision as to what it's trying to recognize, and then it can take a particular action. And throughout the years, we've seen many patent applications and innovations that have one or even all of these features. And over the years, I think when I first started talking about this topic, we focus a lot on what was really the breakthroughs in deep learning. I think that there's kind of this form of AI that exists in the past where there's a lot of sort of simulated AI, sort of pre-programmed AI. When deep learning took off, we had to really get everyone up to speed on why this was so big and why it sort of played in with our advances in telecommunications, our ability to capture large amounts of data and recognize patterns in the data. And ever since that time, we've seen sort of this breakout of various technologies. And one thing the U.S. Patent Office had done recently was this study of the different applications by different AI components up until 2020. And you can see that the different areas where they've seen a lot of the filings, and knowledge processing is a big one, as is vision and AI hardware. And you see also coming in towards the bottom of that graph is natural language processing, which plays an important part of our presentation today. And one thing we've seen with AI is that it's not really confined to just image recognition. You can take the neural network and you can do many tasks with it. And we've seen it heavily used in factory automation, in personalized content. I think this is one of the more subtle forms of AI that is in our everyday life, is just the targeted recommendations and advertising that we often see. And also we see AI hardware making big steps now, and we'll talk a little bit about that at the end of the presentation. And what we're seeing also is something that can sometimes be referred to as AI component technologies, meaning you have sort of the core of AI, which could be a neural network or some kind of machine learning model, but then it can also contribute to planning, vision-based functions, machine learning, natural language processing, and many different components. And that's part of the reason why we wanted to have this discussion today. AI is generally considered to be one of the fastest growing technology areas in global patent filings. I saw one study saying that there's 28% annual growth from 2018 to 2022. And some of the more higher volume filings are in the area of machine learning, speech recognition, image analysis, and natural language processing systems. And AI is sort of like this tree that keeps branching off into different new areas. And one thing I want to do with this presentation is sort of take a look at a couple of these areas that are really coming up to speed, in particular chatbot technology, and also sort of a component technology that's related to AI in the field of augmented reality or virtual reality. One thing, just a caveat, I'm a U.S. patent attorney, and I think you'll probably hear this presentation from a U.S. patent attorney's perspective, but definitely, the discussion and the issues go well beyond with patent issues, they go well beyond the U.S., and I'll try to touch on some of those issues as much as I can during this presentation. So when we think about AI, sometimes it can be looked at as like there's two sides of AI. In the previous slide, I showed the components of an AI innovation. You have sensors, you have learning, you have some kind of a decision that's being made, and you have some kind of an output. And I kind of look at that as sort of the data analysis side of AI. You put the data in the machine, it makes a prediction, and it can output an action. In that situation, maybe the form doesn't really matter. The other side of that equation, though, is what we should probably look at and call maybe the user experience side of AI, where form may be the actual whole point of it. If you think about something like factory automation, that kind of AI is invisible to the user. But we're starting to see more and more the emergence of user interfaces that are using AI, and very much, they can be just as important to the commercial success of a product as the actual data analysis and prediction performed by AI. And one of the things that is an emerging area of artificial intelligence is this software and functionality that performs what we might consider to be human-like output, meaning the data could be the same, what the AI innovation is trying to output, but the more they can make it sort of pass as human has become much more significant, especially as we have more of these interfaces popping up in our everyday lives. So a big driver of that discussion in the news was the emergence of ChatGPT, which came at the end of last year, and it's basically an AI chatbot. It was developed by OpenAI, and it's considered to be very, very accurate in terms of its ability to produce conversation. And make quick decisions about its output in terms of making a conversation. And it really provides detailed responses, articulate answers, and really what it's trying to do is almost pass as a human. And one of the reasons why it's made a lot of the big news headlines is that people have submitted essays to colleges generated by the ChatGPT, and the professors can't tell which one's written by the student, which one's written by the AI. And that is, one of the goals of chatbot technology is trying to pass as human. And, I had actually never used ChatGPT until very recently. I decided to give it a try. I logged on, and I asked it a question. I said, hey, can you provide an introduction to a presentation on artificial intelligence and patenting chatbot technology, and also include a joke related to patents as well? And immediately it starts to spit out all these different paragraphs, all these different lines that, could look like they're written by a human. Probably spent like maybe an hour writing out this page-long response, and you can see it on the screen right now. And for the most part, yeah, it looks like a real person could have written this. And it's interesting to see how it actually produces this in real time. And one thing though I definitely noticed is that when I asked it to make a joke, it did give me a joke. It was a little bit of a generic joke, not really related to patents. So I think that we can rest assured that actual wit and being clever is still something that AI is having a hard time doing. But I encourage you to give it a try, see what actually happens, and it does show kind of this really groundbreaking ability to produce this output instantaneously to the context that I give it. So that's what ChatGPT is doing. This is why it's considered to be such a disruptor in this area. And it is important though. Chatbot technology, we've all experienced it in some form or another throughout the years. Probably, if we consider to be, automation to be the goal, it's been done very badly in the past, and it's slowly getting better. You probably remember the days when we're trying to call someone at a company for support, and we get the automated support voice activation on the phone, and it's saying, press 1 for this, press 2 for that. It can be very frustrating. Sometimes you just want to hit the operator button as fast as you can, talk to a real human being, and just make it go much more fast and efficiently. Nowadays, if you get on a computer and you're trying to get technical support, you have the option to open up a support chat window, and oftentimes this is run by a chatbot. It's an automated feature that is going to ask you questions, and you're going to give it answers. It's going to try to narrow down what your specific problem is and try to give you an accurate response. And this can also be it can be a smooth experience, or it can be a very frustrating experience. And there's an article by Forbes that was written recently that talked about how these negative chatbot experiences can drive away customers. So to actually make the chatbots work better and more human-like is a very important goal for a lot of companies. And in particular, it's that idea that it's passing off as human. So one thing I try to do, I've started to see more applications come my way in this field is really look at some of these challenges in this particular form of AI, this form of emerging AI. You're going to probably see a rush of patent filings over the next coming years because of the success of something like ChatGPT and all the big competitor applications that are coming from other companies like Google and such. And for patent practitioners, we have to understand what this is going to involve in terms of claim challenges, intellectual property protection challenges across the board. So one thing that I've started to notice in chatbot technology is, one of the biggest challenges is that you're trying to claim elements which capture human-like elements, and you're trying to do this while avoiding certain red flags at either the U.S. Patent Office or any other patent office across the globe. And really, it can probably boil down to three major issues, which are probably the main three issues for a lot of applications, but they involve indefiniteness. Are the claims clear? Are they ambiguous? Written description issues, which I'm going to touch on a lot in this presentation, especially with the Supreme Court case of Amgen v. Sanofi, which is currently pending. And also, of course, subject matter eligibility issues. I think that anytime you're trying to do something that is done by humans, there's going to be a challenge to how you get that past the hurdles, both in the U.S., in Europe, and across the world with regards to subject matter eligibility. So one thing I try to do is try to find examples of what actually happens when people try to claim chatbot technology. And I found a few examples, a couple examples I'm going to show in the presentation today. If you want to know the actual patent numbers here, I can gladly give that to you separately. Sometimes I want to avoid actually pointing out specific patents or applications in case the actual practitioners in the audience make that a weird situation. But I found an interesting chatbot patent. This one relates to a dialogue system where the background of this patent was you have a user and he's actually interacting with two separate chatbots. And the chatbots are trying to convey information to the user in the form of play acting. And they're trying to cause almost like a group dialogue with the user so that the user is actually more likely to pay attention and not get bored. And so what'll happen is they'll try to convey information to the user, but they'll try to do it in an interesting way where they almost intentionally try to confuse the user at the beginning with one of the chatbots. And the user is almost forced to pay attention and say, like what's going on there. And then another robot kind of joins in on the user confusion as if to kind of help the conversation along. And so you see an example of this actual chatbot functionality in the screen, where you may have one of the chatbots R1, robot one, where the idea is that the user needs to replace their dishwasher, and the chatbots in whatever home environment are trying to alert the user to this problem. They're saying, please replace it, it's not working. The user says, what are you talking about? And then, the robot says the air conditioner. The user says the air conditioner. And then at this point, the first chatbot is sort of getting sort of a vague response from the user, but to help the conversation along, another robot's actually going to ask the question that really the user should ask, but the user's not really asking it yet. So it kind of jumps in and says, well, why do you think the air conditioner is not functioning? And then the robot can respond directly to that question. And it's almost a way to facilitate a conversation where the user may not be giving the exact answer that is needed to push the conversation along. So another robot is jumping in to provide the necessary question and sort of give the user sort of an ally too in the conversation. And it's a way to kind of keep the user's attention, make the user feel more comfortable. But it's an interesting idea, an interesting innovation, and it's trying to solve a particular problem. So one question is, what does a claim for something like this look like? So here's an example of a claim from this case. And if you recall, one of the goals is to confuse the user at the beginning. You don't describe the dishwasher, say something's not working. So they have something called a leap in logic utterance, which is an element described in the specification. And you actually have to put this in the claim somehow. You have to say you have a sentence structure made up of a premise, an interpretation, and a conclusion. And the system is going to generate a leap in logic utterance, which is an utterance missing partial information on the premise. Now, if you think about that from both the patent drafting perspective and the patent claim perspective, this is a unique challenge. You're trying to describe this thing where a chatbot is talking to a human and he has to confuse a human. Well, that becomes a challenge for the patent practitioner. Like, we have to claim this in a way that is a definite item and it's accurate describing what's actually happening. So this is what the claim actually includes. And we use this phrase leap in logic utterance. So this claim in this example shows you sort of the unique challenge in the chatbot world, meaning you're not trying to say, detect data one, output certain types of data, perform data analysis. You're actually trying to describe something you can see in example form in a dialogue. You have to boil that down to specific claim language. Another example, chatbot Batten 2. All right, this is sort of a machine learning environment where they're trying to get a machine learning ability to offer an emotion with an output. So in the past, you might have to put a specific label to the chatbot, say to offer maybe an apologetic tone or happy tone. They want to do this with machine learning techniques without a label in the output side of it. So they're actually going to train it to learn the context of what a situation is, so it can offer an apology type of emotion or a sad kind of emotion if necessary, or if the situation is different, a different kind of emotion, without requiring a specific label to go along with the output text. So you can see that if the situation involves a loan being denied, the chatbot can recognize situations, say, we are sorry for informing you so late, we cannot offer you this loan, and it's styled a very certain way. And how is this claimed, though? Well, you see, they actually use the phrase, there's a lot of technical data here about training the actual model, but I want you to focus in on the underlying portion where it says, the TTS model is configured to output the spoken utterance with an emotion. And, it's unusual to kind of use these kind of terms in a claim sometimes, like something like an emotion. You have to really define that very clearly. Maybe it's understood based on the specification what that emotion is, but it again presents a challenge with developing a chatbot patent that is trying to pass as human. And you can't just have technical terms. Sometimes you have to mix them with something that is a little bit harder to describe. And we're starting to see more and more applications that are in this area where you're trying to claim something that does kind of this sort of indefinite thing that humans do in dialogue, right? So what we're getting these observations. Sorry, just a little bit here. So I went too far. So in chatbot technology, what we're seeing is that the innovations, they can cover function, form, or both. Kind of the function is the accuracy in the output, meaning the user is trying to get an answer to a question in most situations. If it's technical support, they're trying to find out, how to solve their problem. But then there's the form, trying to make it sound less robotic, trying to make it sound like they're not talking to a robot. I think people will get very frustrated once they realize they're talking to AI. And so chatbot technology can cover innovations in the functional aspect, the form aspect, or both. And the claims, as you saw in these two examples, and this is really the challenge for a lot of patent practitioners out there, is that they may necessarily require that you utilize non-technical terminology. Remember, we use these phrases, leap in logic utterance, emotion. And the goal is really twofold there. One is to accurately define what's happening, but the goal is to broadly claim of what your actual invention is doing. And you can give it specific examples. I mean, if you restrict your emotion to output the word sorry when there is some kind of delay involved in the information, that's easy to claim, but it's very narrow. So if you just say output an emotion, you're trying to get that broad coverage with that non-technical term. And when I think about the challenges with chatbot technology, it definitely does cover the challenges of indefiniteness, and you see that with these claim terms. You have leap in logic utterance, you have the word emotion. Strict examiner can really come down on that and say, which emotion are you talking about specifically? What do you mean by a leap in logic utterance? And you really have to make sure your terms are either defined in the claim or defined in the spec in such a way that you don't have these issues, either when you're trying to get the patent allowed or when you're maybe litigating it later in a future challenge. And we see the issues with written description as well. I think I'm going to cover this more later. We talk about Amgen and Sanofi, but does it actually cover all emotions being outputted based on the context. And I'm gonna come back to that claim when we talk about Amgen, but that's a big issue for these kind of claims. And then also subject matter eligibility. This is automation, right? So you're automating something that a human can do if a human is doing naturally, and you have to be very careful how you claim these things. There's a famous case that was decided that sort of helped clarify subject matter eligibility in the U.S. It's called McGraw v. Bandai. And this case involved automating sort of the animated character on a screen that will have lip movement that goes with the words that are being spoken out loud. And previously, it was done mainly by a human operator on the program. And this software actually was able to do it automatically based on specific rules, based on the text that was involved. Initially, it was held to be non-patent eligible, but the Federal Circuit said, no, this is actually patent eligible under 35 U.S.C. 101. And the big takeaway from that was that the claim was based on specific rules that were limited to how the computer was doing it. And I think that's the key with these kind of claims, is that you want to make it happen the way that a computer would do it, very specifically different than the way the human would do it. Now, imagine that if the robot or the chatbot in a situation is trying to inject a joke into the dialogue. And maybe you say, inject a joke at the beginning of a conversation, a predetermined joke, or inject a joke periodically throughout the conversation. That may be objected to under 101 because that's kind of the human approach to maybe any kind of dialogue, is to provide an intro joke or a joke throughout. But think about the way the computer does, the human does. You want to define those things a little differently. You want to say, detect a pause that is greater than a threshold amount of time and insert a joke when the amount of time that the user doesn't respond exceeds a threshold. That would be the way a computer does it. A human doesn't really operate that way, but a computer is looking for thresholds, moments of silence that last too long, or if it's looking for certain categories of words input from the user that are going to trigger a very specific response. So when you're trying to develop your claims in this area of technology, you'd be mindful of the way a human does it versus the rules that the computer has to do it. And you may have to have those in your claims to overcome the 101 hurdle. So another issue with chatbot technology, and this is sort of a general area of law that is hitting a lot of AI, has to do with copyright protection. And in particular with generative AI that can produce content on its own or with very little input or certain inputs. And the U.S. Copyright Office recently clarified its examination and registration practice for works that are produced based on AI. And essentially what it's saying is that only material produced by human creativity can be the subject of copyright protections, since the term author is human specific. Because what's happening now is you're seeing AI that can produce entire songs, entire writings, or even movies. And the intellectual property issues, while they definitely touch the areas of patent law, probably they can be a bigger issue with copyright protection, especially when it's generative AI. And I think ChatGPT is definitely going to fall into this category where it produces whole new texts just with a very little bit of input. And we've seen this problem with patents, with AI as an inventor, and the jurisdictions are coming down very similarly, where they want some kind of human involved in the ownership process, or the sort of the attribute process, where the human must be the inventor, or the human must be the author, where there has to be some human creativity involved. And we're starting to see the Copyright Office come down in a similar vein as this. I'm not a copyright specialist lawyer. We're going to see how this plays out probably in the next few years, hopefully through a lot of illuminating court cases. And this is definitely an issue that people in the chatbot space have to pay attention to as well, especially when you're actually using the product itself. So another part of AI that I want to talk about today is augmented reality. Sometimes looked at this AR, sometimes it's mixed with virtual reality as well. I'm going to stick to AR for the purposes of this presentation, but it also fits into that category of technology that is on the user experience side of things. And we talked about component technology, and augmented reality, just as a background, it can be related to technology that overlays something in the real world environment with a computer generated one. And it can enhance the user's experience, maybe shift their perspective in a certain way. And it can be used from everything from gaming to shopping. It usually has a display component involved, such as a smartphone or headset. And sometimes advancements in augmented reality can be made through advancements in camera technology, such as maybe a 360-degree camera, or advancements in animation, network infrastructure with the amount of data that's involved. And we're also starting to see how AI plays into augmented reality. We see it, in the area of chatbots for one thing. We often see it in like sort of live action video as well. And I'm going to get to the Pokemon case in a second. Just as an example, I went to the mall last weekend with my daughter, and there's a kiosk at the mall. You sit down, you put on the virtual reality headset, and you go on the simulator roller coaster ride. You're on the roller coaster. You can look around, see the different parts of the track, see dinosaurs coming at you. It's a lot of fun. A really interesting experience. And you can see though how AI can play to that. That is sort of pre-recorded augmented reality, where you're not going to get sort of real-time adjustment to who you are. But you can imagine that, with advancements in AI, you can see the adjustments that AI can make to your augmented reality experience. And you can see it in shopping at the mall, in product recommendations, in navigation. And I think augmented reality is starting to leverage certain aspects of AI, which includes the things as object recognition, speech recognition, positional tracking, and situational virtual displayed objects. And that has to do with very personalized content coming at you in your augmented reality experience. So I think AR is going to emerge as a big component technology to AI, and you're starting to see it with Facebook's investment in the metaverse and other technologies that are coming just through your phone itself. And there's been a couple cases that kind of show some of the challenges that face people in the AR space. I talked about Pokemon Go. It's the game where you can use your phone, you can see different characters in your real world environment and play an interactive game, to capture different objects and score points and do different things basically in your own environment. It's probably the way that a lot of people were introduced to augmented reality to begin with. There was a recent infringement suit brought by NantWorks against the makers of Pokemon Go. And in that case, the issue of 35 U.S.C. 101 came up, where summary judgment was actually granted, founding the claims in this case to be patent ineligible. And in that case, they found that the claims were directed to an abstract idea and not patent eligible under 35 U.S.C. 101. What was interesting about this case was that, the claims were directed to solving a technical problem in the AR space, by placing the correct virtual objects in the correct location of an AR experience. However, the judge in that case agreed with with Niantic's assertion that they're directed to the straightforward concept, sort of similar to giving information to a user based on location on a map. And there was elements of certain claims that were related to rendering at least one of the more AR contact objects associated with a tile sub area on the display based on the view of interest, and a dependent claim which is directed to one or more AR content objects rendered on the display with an overall image related to the real world. And these claims, if you look at them, they look like augmented reality type claims. The challenge is to overlay an object in a very particular way that may solve some problem or some technical challenge to making this happen in the real world. But in the case, these are argued as being interpreted as being equivalent to putting stickers on a map. And you're going to see this kind of characterization show up in the next case as well. But this really struck me. It said, okay, this is actual tangible technology. Person puts on a VR headset, they see it on their phone, they see an image overlaid in the real world environment. But in a court environment, they bring up the analogy of stickers on a map, and actually, it was persuasive. This is found to be directed to an abstract idea. And this kind of shows you the different challenges involved with getting an AR patent through different jurisdictions. Another case that was litigated was ESP versus HTC. And this particular patent was directed to kind of a way in which you detect the three-dimensional pose and orientation of the user itself based on the use of photo detectors and stationary light sensors. And it's kind of like, a different way to do motion capture of the user while they're in the AR VR environment. This one also went before the district court for an Alice motion to see if it could be, found to be patent directed to non-patent subject matter at the onset and get the case invalidated right away. And the defendants in this case, HTC, they characterize ESPI's claims as reciting the abstract concepts of observing visible points in space and determining the pose and orientation of an object relative to the viewer based on such data. And this is the important part here. They describe the claims as an attempt to patent the abstract process of using objects as tools to determine one's position, as sailors have done by looking at the stars for centuries. The district court, they thought this was a close call, but they actually found the claims survived dismissal on the Alice grant. So the case proceeded. It was later actually found summary judgment as just not enough evidence being found that HTC actually infringed this particular patent, but it did survive the Alice motion on a close call. So these are two examples of AR patents being subject to litigation in the U.S. And we see a couple observations from these cases. They demonstrate that that there will be challenges to obtaining these kind of patents in the fields of augmented reality, virtual reality. And one of the strategies that's going to be used, especially on 101, is to oversimplify the patent features, especially if you're trying to defend against infringement in this case. And you saw in the first case, they said, yeah, this is just like putting stickers over a map. The second case, yeah, it's the same thing that sailors have been doing for years. And so what you have to think about as a patent practitioner is, including those key details that relate to the technical problems in AR and VR. If you imagine that, one of the technical problems is maybe not just overlaying an image, but overlaying it with certain depth, certain lighting effects happening that make it, mesh well with the real-time environment. But you really want to make sure those features come out in your claim so that it cannot be oversimplified either by the patent examiner or by future challengers, because you never know who the audience will be in the court system. So, touching base with what we see in some of these AI inventions, there's also a copyright issue that also goes with augmented reality. And one of the things we're seeing is this idea of virtual trademarks. You can imagine that, in the augmented reality space, you could actually have virtual trademarks on anything where it wasn't on a physical object before. And there's some discussion in the community how that can create sort of a false connection. You can put a logo, on the Washington Monument, and it can almost imply that the Washington Monument somehow endorses a certain company. And while these litigation battles haven't really played out yet in full, you can put the ability to put virtual trademarks anywhere in the augmented space can cause a lot of issues. You can put competitors' products, hide them with another person's trademark. Things like that can occur in the augmented reality space. You're also seeing, in the metaverse or in a complete virtual reality space, how you might have to have a whole different set of trademark registration occurring to actually get trademarks that are effective in both the virtual space and in the real world. And you're seeing companies try to get ahead of this, and you see different fashion companies, different sports marketing companies, start to apply for virtual trademarks ahead of time, anticipating there could be some issues with this coming down the road. So if you're in, this area, you definitely want to think in how, if a virtual trademark is necessary for your brand in the augmented reality space. And yeah, it's another interesting area of this emerging area of AI and IP. Okay, so the previous slides talked a lot about these emerging fields of AI that are becoming big issues. And one of the things I mentioned when I was talking about the chatbot technology, especially, was the problem with written description. It's based on one of the older statutes in patent law, 35 U.S.C. 112A, which used to be 35 U.S.C. 112 first paragraph. And there's equivalence of this law in different jurisdictions around the world. But essentially, it requires that the specification is written in clear and concise language, and it enables a person skilled in the art to make and use the invention. And especially with regards to the enablement requirement, kind of the issue that is triggered here is, what right do you have to broadly claim something? And it has to do with the issue of genus and species claims, where you may disclose certain examples of a technology in your specification, but you're claiming sort of the broad genus to those examples, and what are you allowed to do? And in previous guidance examples, the MPEP has said that you must have satisfactory disclosure of a representative number, and it may depend on the person of ordinary skill in the art, the recognizer in possession of the necessary common attributes, possessed by the members of the genus and view of the species disclosed. And if it's an unpredictable art, an adequate written description, may embrace widely variant species, which cannot be achieved by disclosing only one species within the genus. So the more unpredictable, the more species you probably have to disclose. It's kind of the general guidance that they're giving patent examiners at the USPTO. And we've seen this happen, in actual court cases. For mechanical inventions, we have a case of Astion versus Ashley Furniture, where they described mechanical inventions as fairly predictable. So there's a lower level of detail required to satisfy the written description requirement. And a reasonable fact finder could find that they would understand the specification discloses certain mechanical features in that case. In a different case, directive software, Transperfect versus Mattel, they found that there wasn't enough detail in the specification from the claim their plugin technology broadly, because person of ordinary skill in the art would not have understood that the inventors of this patent possessed and described a plugin that could perform a translation without using replacement hyperlinks. So you see how the actual field can cause predictability to kind of swing both ways on the spectrum. More recently, though, the written description requirement, especially the enablement requirement, has gotten even more scrutiny. Yeah, make sure this goes through. You've probably heard of this case that's before the Supreme Court right now, Amgen versus Sanofi. This is a case involving antibody patents, specifically related to certain types of cholesterol. And at the federal circuit level, they took what was kind of considered to be a stricter enablement view of 35 U.S.C. 112. And what they what was always kind of asked in this enablement inquiry was, can the invention be made or used without undue experimentation? But what the Federal Circuit said when they found that these the claims of this antibody patent were not enabled, they said it's important to consider that the quantity of experimentation that would be required to make and use is not only limited to the number of embodiments that the patent discloses, but also the full scope of the claim. So if you think about, there might be, maybe 10 examples or 7 examples in the specification, And if your claim is describing something so broadly, they'll ask, does your actual, are you actually allowing the full scope of the claim beyond those examples to be enabled that wouldn't require, unnecessary experimentation? And it was that full scope language that really kind of was raising some eyebrows. So in front of the Supreme Court, they're asking whether enablement governed by the statute requirement, whether it must enable those skilled in the art to reach the full scope of the claim without undue experimentation. Whether you must cumulatively identify and make all or nearly all embodiments in the invention without substantial time and effort. And yeah, this is kind of a rehash that last slide, but that's the question before the court now, the Supreme Court. They're trying to see whether enablement is governed by the statute requirement that you must enable those to reach the full scope of the claims without undue experimentation. And one of the reasons why this case is so important is that we've seen this before, right? When the Supreme Court takes up one of the major U.S. patent statutes, even if the case facts are directed to one form of technology, it can have a huge ripple effect across the entire, across all patentable inventions. We saw with Alice versus CLS Bank, that was with 35 U.S.C. 101. That was based on a very specific financial services patent application, but the ramifications of that case were felt through almost all software applications across the board, including artificial intelligence. And again, this case on written description and the enablement requirement is very important to software and especially artificial intelligence. In the AI space, recognition of a broad number of objects in a particular field is sort of the ultimate goal of many AI-based inventions. We saw those examples on the previous slides. The chatbot claim that that I showed you from an actual patent, it's saying output a specific emotion. Emotion is a very broad term. Did your specification enable you to output, a phrase that corresponds with every conceivable emotion out there? It definitely knows when to say sorry, but is there some unique situation that the patent practitioner didn't think of that, could require undue experimentation to make the invention work? And that's kind of what's at stake in this case, especially with regards to AI. Consider, this following scenario. We have an object recognition system for a self-driving car, has a patent claim which includes hypothetical claim limitation. Send a signal to a car to take action in response to detecting a non-vehicle moving object within Y feet of the car. The specification describes taking into account certain non-vehicle objects that may be recognized in video images, such as pedestrians on bicycle, and others. And you can imagine that in the space of self-driving cars, they're really keen on trying to make sure that they don't hit certain objects on the road. And want to definitely detect pedestrians on bicycles. But the actual claim is saying detect a non-vehicle moving object. Since the full scope of the claim covers detection of any non-vehicle moving object, the Amgen decision would affect this kind of claim. What if there's something else, like a bird or something, that is not, has the same features as a pedestrian or a bicycle. Maybe it's not moving at a certain speed, maybe it has a certain shape. And some other technology, does recognize a challenge in recognize those objects. This kind of case would face scrutiny for that kind of claim, for that kind of challenge. So you can see in AI, the goal is broad recognition in many cases. This kind of case we're looking at very closely because it will affect how we claim these kind of elements, both functionally, and also how we disclose them in our patent applications. Like, what do we have to do to hit sort of a threshold amount to achieve a certain claim status? And we're gonna have to be really careful going forward. Now, there's different incentives involved with which way the Supreme Court's going, but we're keeping a very close eye on this case because depending which way they slide the scale, it will affect how we treat applications like this with any kind of a genus species aspect very carefully. Okay, so a couple other issues that I'm going to touch base on very quickly. Yeah, so this slide just sort of covers, what I just described. So I'll just skip right past that. We talk about different emergent areas of IP. One of the areas that we do talk a lot about is this need to protect the data that fuels AI. I think we've covered this in a lot of IAM webinars in the past, but there's well, you can't get this through patent protection. You look at non-patent methods for protecting certain data sets as an asset. Trade secret protection is preferable, especially when other types of IP protections are unavailable, such as patent protection. The cost will outweigh the benefits, or there's a need for potential IP protection that extends beyond the term available for other types of IP. Copyright protection, especially when it comes to large sets of data. In certain jurisdictions, you can get protection of an arrangement of material in database, where it's original or creative. I know that in Europe, you can get what they call sui generis database rights that provides limited protection to databases if there's significant investments have been made to obtain, verify, or present the contents. And this is available in Europe, but not the US. So another emerging area of IP outside the patent space especially is how do you actually protect the data that goes into all these advancements? And another area that's growing rapidly is AI hardware. Usually, we don't really, I don't think we talk about this too much in terms of controversial issues because it is a lot based in hardware. But AI chips are a bursting field of AI. They involve GPUs and FPGAs and ASICs that are specialized for AI, and a lot of them can be sometimes put into two categories of it being accelerators or sort of application-focused AI chips. And the issues to watch with AI hardware, I think when you have a thing that's sort of based in legacy technology, but it's sort of shifting with advancements, sort of like communication space, is avoiding the obvious disinfringement issues from legacy chip patents. One of the things I'm always arguing with patent examiners with something like this is that you have to look at the claims as a whole. And there's going to be a lot of art out there which kind of takes piecemeal what these AI chips are doing, and examiners and challengers will try to piece them together to make these claims look obvious. And you have to really have a good argument as to why, as a whole, this AI hardware is non-obvious. Because this is an AI chip, you can't kind of get over these hurdles by reciting an intended use for AI. You have to have actual features that are pretty much used proactively for solving some kind of problem with AI. And you want to use proper claiming for novelty based on a mixture of hardware and functional features. Maybe you'll have structure, but you also want to be mindful of, are you functionally claiming properly when necessary, so you're not pinned down by the hardware of your chip. You have to have a certain kind of structure when your novelty is actually in the functionality of your chip. So one thing we're going to start paying attention to going forward is sort of the advancement in AI hardware and the patent issues that affect these. And I do apologize that I kind of went through the last slides probably a little bit quickly, but I do see the time is starting to run out. We'll try to take a look at some of the questions we have from the audience in the question portion. And my email is on the screen right now, and so please email me any questions you have. And if you have any ideas that you want to see us discuss in future webinars or in future blog posts on the AIpatentsblog.com, please feel free to ask me questions there as well, and we can try to make those a topic. One of the questions we had was, what are our thoughts on how to best patent in new machine learning architecture models rather than leveraging pre-existing trained models for a certain use? I think that different presentation, I probably would have put up a slide called kind of the black box problem with an AI patent. If you have a neural network or machine learning model, to actually claim the finally trained model is very difficult because it is sort of trained based on sort of access to large sets of data. And if you have a specific feature that's different than the actual previous algorithms, yes, you can patent those features, but it is one of those things where you really have to have kind of a very specific feature that is almost like a method step that's done differently in the process of developing those neural networks. I think that going inside the black box, if you have a specific sort of algorithmic step that makes your final results improved over any previous version, then yeah, definitely you can treat that as sort of a software method claim at that point, and argue that this is an improvement to all previous known machine learning models. But there is a definite black box problem with claiming AI architectures, and that is sort of a constant challenge we're seeing in this industry. Another question: are AI patents enforceable? If yes, are examples of AI patents being awarded damages being infringed? Yes, AI patents are definitely enforceable, assuming they can survive all those challenges that we talked about, one-on-one challenges, different forms. And yeah, like off the top of my head, I can't think of a specific damage award, but you're starting to see more cases kind of working their way through the system that are based in AI. You're probably going to see now that the technology is taking root by larger companies such as Google, such as Microsoft. You're probably going to see a lot of non-practice entities, kind of digging up their old patents, starting to say, yeah, we did something like that. But off the top of my head, I can't think of a large damage award based on an AI patent quite yet. But because of the stakes, because of the kind of the stakes that major players have, you're going to see a lot of this probably go through the courts pretty soon. You're starting to see that already with the lawsuits already talked about in this case. And patents which were not invalidated by an infringer. I think I have that question. I think, if someone wants to email more specific cases, I think the McGrover's Bandai case, the one case I talked about, which was not invalidated under 101, that had to do with automating the lip-sync technology. But we're starting to see more of these cases go through the system, and I think it's kind of an open-ended question. These cases that are going to, these AI patents are going to kind of stand the scrutiny. But that's what a lot of the stakeholders, I think, in this forum are looking at. How do you protect against these challenges going forward, and how do you sort of get a patent that is durable and that survives most of jurisdictional challenges before the different panels across the world, and also survives all the future challenges coming in court. And this presentation isn't designed to cover all forms of AI. I think I want to touch on a couple of new forms of AI that are starting to make their way through the news, starting to see more disruption in our technology landscape. And I'm happy to answer any of the questions about AI that you may have. But I do believe that is all the time we have for today. I do appreciate everyone tuning in for this this webinar, and I look forward to either talking to you directly. You can find me on LinkedIn, or if if you're ever in the Washington D.C. area, you want to meet and greet, I'd be happy to as well. But thank you to IAM Alksaji for the time granted for this presentation today. I hope it was helpful for most of you.